if we had that kind of effect and people were listening to us and making decisions based on what we said, and if that is the case, all I'm asking you to do is follow the law. Follow the law.
All right, welcome to the Judgemental podcast. Let's get right into it. We were down at court yesterday. Tuesday, we did judicial roll call twice. Per usual, district court not showing up like they should be, huh?
Yeah, I mean, there was a lot of activity on one floor, and then nothing really happening on another floor. The first floor actually finally had some activity because they're using one of the courtrooms for a jury room while they remodeled the one over in the judicial center.
Oh, yeah, that was
So,
like a total trick. I just think district court literally is operating with courtrooms at half capacity, period, end of story most days.
no,
Like,
it
I
seems
think
like
that's,
it. I mean,
yeah.
everything about that building seems like it's barely running. You had the help desk. You have two different help desks there. One's been shut down every time we've been in there. The escalators are shut down and just never work.
Mhm.
You've got floors that are pretty much dark and all the doors locked. And you've got, you know, basically half the courtrooms open, if that. And some of the judges were on the bench both in the morning and the afternoon, but it seemed like a
Yeah,
lot of them switched.
yep, I think there were 2 judges actually, and now one of the judges, I think that was the first time we've ever seen her on the bench. I wanna verify that before we say her name out loud.
Yeah.
But I was really happy with circuit court. I think 11 out of 13 at
Yeah.
10 AM. I mean, that's 85%. Like, there certainly we get a lot of hate about from attorneys, I think, or people that are in the court system in other jurisdictions, like, just because they're not on the bench doesn't mean they're not working. You and I have obviously said that 1,400 times on this podcast. You know what I mean?
Yeah.
But generally speaking, I think in particular, Mondays and Tuesdays, most courtrooms should be open most of the times, given the way the structure of how courts work here in Louisville.
Yeah. No, I can't disagree with that. I was impressed with circuit court.
Hmm.
Family court, it was about like last time we were there,
Yep,
about half and
70%.
half. Yeah. Oh,
Hmm.
70% of family.
Yeah.
Was that,
Wait.
go ahead.
Oh, I was going to say the other thing though too is they have all of these confidential dockets, and so we can't see how the judges, like what time the judge is actually getting to court. We actually got a message on our judgy today. Like, I'm sitting outside the TikTok judge and she's late. And it's like, I think that's happening all the time. Like 8:30 dockets are starting at 10:30, which is unacceptable.
Well, yeah, we've heard now in 24 hours from 3 different people, in fact, that they have been waiting since the early morning docket. And we spoke to a gentleman yesterday who was sitting there, oh, what was it, 1:30 ish,
Yeah.
and he had been there since the morning docket, and just sitting there waiting to be called. And we've been hearing that the dockets have been starting. The 8:30 docket, actually, the cases start being called in at about 10 to 10:30 because the judge didn't arrive until then. And that's
Right.
just all in the last 2 days. We received another message from someone about being over on one of the dockets. So we get messages from people that are sitting over in court and are messaging judges. So
Which is amazing. And the fact that so many people are like waiting to go into court and like watching us, like, I mean,
yep.
judges, just pay attention to this. Like, just go to work. Like, that's the easy part. Go to work, which I think kind of segues into, I've talked a little about this on my personal page, but we felt like something was happening last Monday when we were in court, right? Like, for sure.
Oh, there was no doubt. So we heard multiple references to waiving Adair, which is
Hmm.
Adair versus Emberton, a case that came out in July of 2024 that sort of reiterates what the law already said about FOCs and their role and what they have to do, and that they have to file a report 10 days ahead of time before they can advise the court. There's a right to cross examine the FOC. And so we saw FOCs appearing at motion hour, but refusing to actually speak about their opinion, which is par for. I mean, what is the normal thing at a motion hour is the court asks the FOC what they think about the motion,
Yeah.
and
Yeah.
they just don't they don't get sworn in. They don't file a report, and that happened all the time. We've seen a change, and that part, I think, that there's actually a change to it is fantastic. The change that we saw, however, is quite concerning.
Yeah, absolutely. Well, I think we were in Angela Johnson's courtroom and it was an FOC. And of course, Angela looks to the FOC, says something. Well, this FOC was like, Your Honor, Emberton hasn't been waived, I think was her exact verbiage. And then we saw in Division 3 for sure. And then also in Division 5 about we're waiving Adair. It was almost like it was a talking point, like there had been some sort of meeting or something where this was going to be the new strategy. At least
Yeah,
that's what I thought.
I was very interested in that too. The similar language being used by multiple FOCs
Mhm.
tells me that there's been some sort of communication, some sort of a meeting, where there's been guidance maybe from the courts. I don't know. It's concerning though, because the rights in Emberton are set out very clearly in the Kentucky Revised Statutes. Like
Right.
this is not just a local rule. These aren't just procedural things. The FOC has to file a report 10 days before advising the court of what they feel is in the child's best interest. They don't get to show up for motion hour. They don't get to show up and advise the court without being sworn in and without having filed that report, which is the way that they've been treated for so long.
Yeah.
Um,
And it's like, I don't think people don't understand fully. Even me, when I was practicing, like I didn't use a lot of FOCs. I'm not a fan of FOCs. I know there are attorneys that are big fans, and it's an event. And I think that, when I'm wrong, I'm wrong. I think that if it's done appropriately, properly, and thoroughly, I could see an avenue for where it would be really helpful. But this is for all the listeners too. This is literally your case. Like you literally appealed this case and
yes.
you are the one that got, and this was a case that when it came out, I remember I did a TikTok on it and it kind of blew up because it was Brian Gatewood and just the demeanor to which he spoke to the litigants was in and of itself a problem. But FOCs are fact witnesses, correct?
They are
And
fact witnesses. Correct.
and they are supposed to investigate what is in the child's best interest, correct?
Yes. That's what
And
the
they're
statute
supposed
says.
Yeah, and they're supposed to issue a report and give it to everyone. And I think the rule, like the KRS statute says it has to actually be properly filed with the circuit clerk, right? Am I
It
right on that?
actually the clerk is supposed to send it out to the parties or to the litigants after it's filed.
And it's clear from the legislative intent that the purpose of this FOC role is to get something in writing. That way, the court has something to look at to make recommendations, but yet all of the attorneys and people involved have the ability to cross examine and to investigate the investigator, right?
Yeah, I mean, I think the idea is that fact family law cases are very fact specific. They are very different than, let's say, a contract dispute or a slip and fall that I mean, they involve sometimes years and years of, there'll be therapists, there'll be doctors, there'll be all kinds of things, and it's difficult for courts to make those findings of fact on their own just from the contents of testimony at hearings. So I can understand the theory behind it that you have someone appointed that then can advise the court. But because they are advising the court on facts and giving a recommendation under the best interest of the child, there are very clear due process rights at stake there. So this is someone that's making factual findings almost for the court. I mean, they're proposing certain things. The courts usually go along with them. So due process says you have a right to cross-examine,
Mhm.
and it's very clear from the statute that the friend of court has to give the names of the sources of the information, and it gives the parties a right to call and cross-examine the sources of that information as well as the FOC.
Yeah,
So
and the 10-day rule is so important because that allows each parent the time to prepare. And that's what these FOCs weren't doing. Sometimes they were filing it in cases like day of, if they filed it at all.
if they filed it at all, sure.
Mhm.
And I remember when I started raising, objections when things were filed a day or two before the hearing or on the day, and I'd file a motion to strike or I'd make a motion in limine to strike it. And oh man, people would get so annoyed, including the judges. They'd get so annoyed that, well, this would be really helpful to me. Well, I I don't care if it's harmful to my client and it hasn't given me the opportunity to prepare and it wasn't filed within the 10 days. It needs to be stricken. And I don't know. It seems like they're still trying to get around that now. The FOCs are apparently asking people to waive their rights under Emberton, which is interesting because the Emberton decisions states very clearly a party may not waive his or her right of cross-examination prior to the hearing. So I want to know what they are asking people to do prior to the hearing by sending out emails asking if they will waive Emberton so that the friend of court doesn't have to file a report and can just show up at a motion hour or hearing and give a report to the court.
Exactly. Like, so when we first heard it, it was like, well, Your Honor, they haven't waived Emberton. But I wonder if the next move, and I think this is a gut feeling mixed with some information that we have gotten from a plethora of people, my favorite word, but like there is something percolating where they are trying to not have to file a report and they are working in an orchestrated manner to do so. And
Yeah.
I find that to just be a radical notion to think that instead of just doing the job, which the statute, if I'm right, it says the FOC shall file, right?
Yeah,
It's
you got to file
shall.
a report. Yeah, has to file a report.
And so I don't even know, one, if these attorneys have the capability of waiting for their client. Like, that makes me nervous to think an attorney would ever do that in the first place, right?
Yeah, I mean, from my point of view, if you're an attorney and you're asked to waive this and you haven't had a very specific conversation with your client about this is what we're giving up, if this person shows up and says something, I don't get to cross-examine. I don't get to know the sources. I don't get to review the materials or the notes ahead of time. Unless the attorney has had that conversation with their client and they say, oh, yeah, that's fine, we'll waive Adair or Emberton, I don't know how that's not malpractice. I don't know
Oh,
how
yeah.
the attorney should not be liable if the case then goes against their client. I mean, I think that creates a huge problem.
And so it was the first time we saw it. So I wonder if they're going to try to get clients to waive Emberton at every motion hour, or if they're trying to look for like a blanket waiver. I mean, it's problematic either way. And it would have to be, I frankly, I don't think it can be done. I don't think you can waive a due process right like this. It's by statute and by case law.
Yeah, I mean, it's the law twice now. I mean, Garris 43300 sets out the rules for FOCs and the report requirement. Emberton versus Adair didn't create anything new. It just basically said follow the law. Here's what the law clearly requires. Here's the number of ways that the court in that particular case didn't follow the law. And then it says you can't waive the right to cross-examine prior to a hearing. So if an attorney is asked if they would waive Emberton at a motion hour and they've not discussed it with their client, and they waive it, the client's not even there, I don't know. I think that creates a huge problem for the practitioner, but I also think that we have something that to me is very, very troubling. And if there has been some sort of coordination with the judges and the FOCs to find a way to waive a Kentucky statute that is there to protect parents, to waive the actual law and case law that came down and said you can't waive this. And now if we have judges and FOCs coming up with a scheme in order to do that, which I don't know that that's happened. It was just amazing how many people were using the exact same language and how the procedure had just changed so dramatically in multiple motion hours. That's frightening as hell to me.
Well, I mean, to me, I'll use the word. I mean, if there actually is a meeting and there is an attempt to have a meeting of the minds, I mean, it's a conspiracy. It's two or more people and there's an overt act. And I don't even want to say it's a statute. Like you said, it's a statute to protect parents. Yes, of course. But let's take it a step further. Like, literally, your right to parent is constitutionally protected.
Yes.
So this potentially has the potential, allegedly, to be a group of elected officials, attorneys appointed that are granted quasi judicial immunity, and parents that have a constitutional right to protect their children. And there is an orchestrated event, if this is happening, to circumvent that. I mean, that's fucking insane.
Yeah, no, I agree. That scares the crap out of me because I mean, this is a statute. The statute gives rights. The court, the Court of Appeals has said in a published opinion, these are the established rights. These are things that can't be waived. And now it looks like I mean, there's some sort of workaround now to allow FOCs to come in and give testimony filled with hearsay, not be sworn in, and not file a report pursuant to the statute in order to advise the court on what to do on matters of parenting time and custody.
Well, and the bigger thing too is let's look at the timing of this, right? So this order came out, I think you said July, right? So a year
July
ago,
of
over a year
2024,
ago.
correct.
And there was none of this alleged orchestration then. What's the factor? Us going to court and talking about it. No,
Oh,
I'm
if only.
serious.
If
No, but I
only.
mean, I really do think that us reporting on this is what's caused them to realize they need to have some sort of plan, because maybe they weren't following it anyway until we just got on a podcast and started saying, hey, this is a real problem. But like, I think that makes it even more potentially nefarious.
Well, I mean, listen, I would be honored if we had that kind of effect and people were listening to us and making decisions based on what we said. And if that is the case, all I'm asking you to do is follow the law. Follow the law. Let's not come up with plans to circumvent the law to get around it out of convenience. Let's follow the law. Let's give parents their due process rights. Let's take away the power from the FOCs and give it back to the judges so that they do their job, instead of just having the overworked FOC who, like in the Adair case, didn't reach out to the client, even though the court had even recognized that the FOC really needs to talk to the child before making recommendations, and then makes recommendations anyway, and the judge goes along with it. Let's just follow the law. Let's just follow procedure. Let's give people their due process rights, and then no one will have anything to complain about, and we'll move on this podcast.
Yeah, this is like my big thing. This is where I get so frustrated. It's like everybody that, a lot of times in the public, they'll be like, oh, it's a quote unquote, like they're these people, they're going to be outspoken because they didn't get their kids, right? But imagine if you were going through it and then come to find out the judges, the family law attorneys, and the FOCs are like getting together and meeting and making these decisions. Like, how is that helpful to not making someone like feel a certain kind of way about family court? I don't know if I said that articulately, but you know what I mean?
Yeah, absolutely. I mean, it seems that there's been discussion amongst the FOCs and the way to handle Adair and Emberton. The idea of waiving a case law it's something that's odd enough that I don't buy that people are just coming up with that independently and saying virtually the exact same words.
Yeah.
Now, I'm interested to see, and we did not get a chance to see a lot of actual practitioner reaction to that, right? So to the extent that there are any practicing family law attorneys involved in coming up with that workaround, I don't know. I would hope that people that are asked to waive that would be up in arms about it. In fact, I know that some are. Some have reached out to us and say they've been asked to waive Emberton prior to hearings, and can we believe that? So I'm hoping that's the reaction of most of them. But just the whole idea of this scheme in general is just disturbing.
It's bonkers. And also, you wonder if like we have FOCs that have their own private practice. So I want to see if the FOCs in their private practice are waiving Adair versus Emberton. And also, are judges giving people that waive the rule a favorable outcome or more appointments? I mean, it just seems that there is this feel that there could be the potential for quid pro quo.
Sure.
So,
Yeah.
but we are going to
It
have
feels
to.
dirty.
Yes, we are going to have to do a full deep dive of Adair versus Emberton just because it's like a 20-minute hearing. I got it. I had been done practicing for a year, and it's all of the things you can imagine in one about the problems and what happens every single day in Louisville Family Court prior to this opinion. I mean, just a judge being unprepared, an FOC being unprepared, the demeanor in the court. And just for clarification purposes, I know this, but you are not the attorney.
No, I wasn't the attorney at the time the actual hearing that was appealed took place. The client was not represented at the time and came to me after I had had some success with the appellate court on another case and asked me to appeal the case.
And it goes back to a common theme where when we were practicing, you and I, we did not see what happened to pro se litigants. And you just wonder how often was this same fact pattern happening? Because if your client had not gotten the means and the wherewithal to hire you, who knows what would have happened?
Oh, I agree. I I agree. I mean, and you say that this case sort of represents things that we see all the time in family law. I mean, one of the things that happened was the court went forward on a hearing on three things, and the hearing was only set for one of those things. The other things were, one was filed the night before, or sorry, the day before, and the other was just a renewed request, I guess, on the spot by one of the attorneys. And the judge went forward and granted that request, granted it before even admitting the mother into the courtroom, not swearing someone in. Anyway, we can get into that. But those are just things that happen so regularly. And that sounds bizarre to anyone outside of family court, I'm sure, and maybe outside of this jurisdiction, but we hear about it happening in cases all over the country. But unfortunately, those are things that just happen. You go in, well, let's just have a powwow. We won't go on the record. Oh, wait, hold on. We'll go on the record in the middle of this little powwow, and then I'm going to make findings based on what was just said to me, in this case, ex parte, just in a basic conversation in complete violation of statute. And I'm going to make the findings, and I've already written them, and then we'll just call the parties in and tell them what we're going to do. And that stuff happens.
Oh, yeah. And I think that's why, again, you have people that say, I got so wronged in family court, or there's no due process in family court. And if you want an example of where there was no due process, you just need to watch the hearing from Adair versus Emberton, because due process was like out the window. I mean, it was just crazy. And for everyone listening, due process is so, the simplest terms is just notice and an opportunity to be heard. You know, and that is the foundation of the American judiciary. I mean, it should be.
Yeah, I mean, certainly it's the only way that our court system can work. You should never expect to go to court and for the court to be presiding over an issue that you had no notice of, have no preparation for, and that you're going to have a quote unquote, expert or appointed witness that gets to basically tell the court what they think they should do, and you don't get to ask any questions.
It gets to play judge, just like literally. And typically in this hearing was not sworn in, right? Yeah, was not sworn in.
No one, it didn't seem like anybody was sworn in.
Which is a whole nother ball game. But now, and tell me if I'm wrong, but we can't obviously give legal advice, but I do want anyone and everyone that is asked to waive Adair versus Emberton. One, I want to know that story, and I want to know the players in your case. So submit those to Judge-Y. But just, I think generally speaking, I cannot imagine a situation in which waiving Adair versus Emberton would be a good idea. Can I say that?
Yeah, that's your opinion. I mean, if I put my advocate hat on and I've got a case where I want something done at motion hour and the court, I mean, would I feel good about it? No, because I think it weakens the entire system. But if the judge asks, if let's say the friend of court wants to say something that benefits my client and basically means I win the motion that's before the court, and the judge says, do you mind if I, will you permit me to speak to Mr., so-and-so? I don't know. I think as an advocate, if it benefits your client, I can see why in certain circumstances people would do it. I think that's an interesting quandary because I don't believe that it's lawful. That's my opinion, not advice, but I want to know. I would like to hear from someone who's been asked to waive it and to tell me the circumstances, why you believe that it was in your client's best interest, how you handled it, and if you felt that it was safe to do without first speaking to your client. I mean, I maybe if the friend of the court had said right beforehand, oh, this is how I feel, and it's very, very strong. But I will say in my career, I've had people tell me that on the phone the night before a hearing, they feel very strongly one way and then come in and say something totally different the next morning.
Yep.
And I wouldn't trust it. So I would like to hear the stories. I'd like to hear both sides. But like Christine said, I would like to hear, I'd like to know what these communications are like, what's coming from the FOCs asking to waive it prior to a hearing, even though the case law says very clearly you can't waive it prior to the hearing.
Yeah. And I also just think this is also just general opinion, but like judges, FOCs, lawyers, like getting together as a group and trying to circumvent the law and taking an overt step to do that. All it takes is for one of y'all to do an overt step too. I mean, this is like basic crim law type stuff. Like, what is it in the event these things are happening at like, if there's like a meeting or like a function, but just like think about what you're a part of, because this is not going to end well if this is actually their strategy, in my opinion.
Well said.
Okay. Awesome, guys. Well, judge-y.com, Judging the Judges on Instagram. Also, tag us in viral clips. Thank you guys so much.
Thanks.
We need some justice. My life is fine, justice.